Welcome, everybody, to Second Tuesdays at PERB. Good to see all of you, and we're going to get started right away. I just wanted to let you know that we are videotaping this session and future sessions. We've got a request from several of you from last month asking that we videotape and try to put it on our website. And so, assuming our website will support a video, we will have it on our website as soon as possible so that those of you who have colleagues who were not able to attend will be able to, your colleagues will be able to see it at their leisure, and as well as there are some of you who, there were some people who were here the last session who said they could not make it to this session, or I think it is in March that they won't be able to make it, and so it'll be available also then. So I warn you that I said I wasn't going to do this, but I'm going to say it anyway. I warn you that if you have any warrants out for your arrest, don't turn around. What? This is a large session, and so the question has always been whether or not we should split the session and have smaller groupings. If I get some comment that the grouping should be smaller, then Mr. Higgins has agreed that he will hold two sessions as opposed to one. It could be on the same day. One would be at this particular time, and then we would have one from 1:30 to 3, or we could hold it on Tuesday and then have an extended session or the second session on another day, any day other than Thursday. So if you have any suggestions about that, please let me know. To be sure, this is probably the largest that this room will, the largest number of people that this room will be able to hold. So if we get more responses, we will have to break it up anyway. But I just wanted to let you know that we are open for suggestions from you. Today we have two of our board members here, and I want to recognize them. That's Ann Hoffman here, and then Donald Wasserman. Where are you? Okay, right there. And just wanted, these are our two of our 5 board members, and thank you very much for coming. Let me introduce our PERB staff. They're sitting over here. We have Erica Bolcom, Kobe Harmon, we have David McFadden, and we have a new member, our supervisor attorney, Lindsay Maxwell. And so those are the people who write all of our decisions and orders, proposals for the agency. And so I wanted to put a face with the work that's done at our agency.
And who are you?
Oh, excuse me. For those of you who don't know, my name is Clarine Martin, and I'm Executive Director of PERB, and I have been Executive Director short of a month, for a year, short of a month. So next month, I will have been in this job for a year, and I've enjoyed it immensely. There was a request for a syllabus, and we thought about that, and we decided not to provide a syllabus for the classes because we wanted you to listen to the lecture as opposed to looking down at a syllabus. But we did offer or provide you with notes from last month's class, and we will provide those notes after every class that we have for you to have for your records. And we'll also probably post them on our website. I'm going to give this group of people some time to get in, and then I will have Mr. Higgins start. So if you will just bear with us for a minute, I think.
Well, there's 2 here, there's 3 here. One there.
Let me also say this too, please, is that when we send out the notices, please respond. Notwithstanding the fact that you've been here today or last month, we need to know how many people are coming so that we can make arrangements if we need to as to the facility. Hopefully, you know, the fire marshals are downstairs on the 7th floor. Hopefully they don't come up here. But I think we're fine. I think we're fine. I saw somebody from the fire department here. But, yeah, but,
You have four spots over here. There's 1, 2, 3, 4 seats over there.
and there's one right here. Okay.
And then 3 up here.
I feel like an usher at church, right here.
That's a good idea. Mr. Higgins did mention, when I told him that we were having a few people, and we'd already, this morning at 8:30, we'd already had 2 people who had come, and they had not signed up, and he said, oh, this is like church. Everybody's welcome. Find a room for us. So, this is like church. Come on in. Church, synagogue, or whatever. I guess synagogues do the same thing. We have water over here, and so if you get thirsty. Here, you can take my thermos.
There's one over here.
Cheryl, you want to close the door? All right, let's get started. For those of you who were here last month, for those of you who were not here last month, let me introduce Mr. John Higgins. Mr. Higgins, as the flyer that we sent out said, is a former board member of the National Labor Relations Board. He has also worked as an acting general counsel and an associate general counsel at the National Labor Relations Board. He's retired now, and he is a professor at Catholic University, where he teaches labor law courses, including labor relations in the public sector. He's also the editor-in-chief of a major labor law treatise called Developing Labor Law, and most labor lawyers who deal, especially in the federal sector, have one on their desk. And as I said before at last session, anything related to labor law, labor relations, always, except for very few matters, always leads back to the National Labor Relations Board. So, Mr. Higgins, it's all yours now.
Well, welcome back, and I'm certainly glad to be here, and I really am thrilled the idea that I'm going to be a star. They're putting me on television. I can hardly wait to tell my grandchildren that they go to the DC PERB site and they'll find me there. This will really be great. I don't know how long they'll watch that kind of a show, but at least they'll see Boobar, as they call me, on the television. Before I begin, I wanted to tell you something that happened right shortly after our last session, our session in December. And because it relates to some of the things, something I talked about, and I thought I'd repeat it to you now. After the session I went to a monthly LERA meeting. LERA is an acronym for Labor and Employment Research Association. It's a successor to an organization called the Industrial Relations Research Association. It's a worldwide organization, and it's made up of labor and management people. Most of, by the way, are not lawyers. They're for real labor practitioners like you. I mean, for really people who are out there negotiating settlements, negotiating contracts, settling disputes, and so forth. And they meet here. The DC chapter meets once a month, and they have a luncheon. And they usually have very good speakers from the public sector and the private sector. people from international, involved in international labor relations. I mention it because, well, for two reasons. One, if you don't belong to LIRA and you're practicing labor relations and employment law, it's something you ought to think about joining. I think it costs $40 a year or something like that. And they have, as I say, monthly luncheons. They're really good speakers. Well, the session that I went to that I wanted to tell you about, the speaker was a man by the name of George Cohen. George just recently retired as director of the Federal Mediation and Conciliation Service. And before that, he was a partner in a law firm called Bredhoff and Kaiser, which is a union law firm here in Washington, and a very, very well-regarded, very well-respected law firm. George, among his clients, for example, the United Steelworkers of America, the National Basketball Players Association, the National Football Players Association. George represented a lot of the really heavy hitters on the labor side in labor relations. And then President Obama named him as director of the Federal Mediation and Conciliation Service. Well, that's a long warm-up to what George said, and that's what I wanted to just tell you. He was talking about his 3 or 4 years as director of FMCS, and he kept using the same word, the word that I used the other day, and I just want to kind of repeat it to you. And he said, the most important thing that he tried to impart as the director of federal mediation was the concept of showing respect for the people on the other side of the table. That there's no point in thinking that you're representing unions well, or thinking that you're representing management well, if you are not trying to build a relationship with that person across the table, even if he or she is, as my wife, who's from the South, would say, hateful. Even if they are nasty, okay? Your job, what the DC government is paying you if you're on the management side, and what the union is paying you for on the union side, is to develop a relationship with those people, because that's what the employees want. The employees want a collective bargaining relationship that's fruitful, and George kept saying that over and over again. I thought to myself, I got to repeat that at the next second Tuesday, because when someone as important as George and the whole labor management community spends a whole speech talking about that, I thought it was something I should talk to you a little bit about. So anyway, that's it. All right. What we're going to talk about today is part one, unfair labor practices. I'm going to have to talk fast if I'm going to try to get through what I want to talk about. What I want to talk about is the unfair labor practice provisions of the statute, okay, the statute that PERB enforces. I'm going to hopefully get all the way up to, but not begin, the discussion of collective bargaining law. Okay, what the NLRB would call Section 8A5, what PERB calls 101.617.04A3, A4 or something like that. I was with the NLRB for 47 years. I have all those citations down. I haven't been with PERB long enough to kind of know them all. But so what I'm trying to get to is talking about the unfair labor practice, all of the unfair labor practice provisions, except for the duty to bargain, and that will be February's session. Okay. Before I begin, let me just mention those notes that we prepared for you. If you notice, those are kind of a summary of what we did at the last class, and you will get a similar summary at the beginning of the next session, so that hopefully when this thing is all done, you'll have a complete set of what we talked about, and in addition to that, of course, you would have a binder which has the PERB rules and regulations, as well as the PERB statute. So you should have a kind of a good library that you can draw upon if you start to get involved in some PERB kinds of issues. All right. If you look at the next to last item on page 2 of those notes, you'll notice a reference to timeliness. And those of you who were paying attention to last class know that we really didn't discuss that at the last class. But because timeliness, or the statute of limitations, so to speak, is considered an aspect of PERB jurisdiction, or the jurisdiction that PERB has to operate in, I added it here, and I want to just spend just a few minutes talking about it, because perhaps for those of you who file unfair labor practice complaints, it may very well be the one place you don't want to make a mistake on. Okay? Anybody know how long the PERB statute of limitations is? What's the statute of limitations? Somebody said something. 120 days, that's right. And that's different, by the way, for those of you who practice private sector labor law, that's different than the NLRB, which is 180 days. But it is an important 120 days, because if you don't make that deadline, you're just plain out of court. There's just no way out of it. Now, let me just, the question though is, 120 days from what? That's the question.
From the event giving rise to, would you believe be unfair labor?
Yes, ma'am. But what if but there are going to be occasions where you don't know about the event. What PERB says, and what the statute, what the PERB decisions say, it's 120 days from the date you knew, or know, or should have known of the unfair labor practice, okay? Now, if the alleged unfair labor practice happens to be a discriminatory discharge, an allegation that somebody was fired because he or she is for the union, that's usually pretty easy. That's pretty easy. The day the employee's given his pink slip and told to be on his way, and you've got 120 days, okay? But sometimes, there are unfair labor practices that are, almost of their nature, are not so obvious. For example, unilateral subcontracting. What do I mean by that? That means that the employer, for instance, takes unit work and starts farming it off to somebody else outside of the agency, and doesn't tell the union, and indeed keeps it a secret. Because if it's a secret, great, then the union, he doesn't have to bargain about it, the union isn't going to be bothering him, and so forth. Well, when does that 120 days start? And 120 days starts from the date you knew or should have known. Now, should you have known? Well, if the very nature of the unfair labor practice is to keep it a secret, then the 120 days is going to start from when the cat gets out of the bag, okay? When the cat gets out of the bag. So it's not 120 days that you in every single instance. Yes, sir.
With that being said, do you have to prove that when you found out?
You may have to. Yes, sir. I suspect, for example, if you file a complaint, and the PERB staff is going to ask you, gee, this happened back 6 months ago, pal. What are you doing here now? And you are going to have to present evidence as to why you didn't know about this until something less than 120 days ago. Okay? So yeah, yes, you may have to prove it. Yeah. Yes, ma'am.
What if the union members know, but the union itself doesn't?
Then it's probably something that you should have known. Okay, if it's something you should have known. Now, you could have a situation, and by the way, they've had cases like this at the NLRB, where the employer secretly agrees to pay an employee something other than the contract wage. Maybe pay them less, or maybe pay them more, whatever it happens to be. There, the employee is a unit employee, but the nature of that unfair labor practice is a secret between the employer and the employee. That's not the kind of situation that I was answering when you asked. But if pretty much everybody in the unit knew, and you didn't, but you probably aren't doing a very good job as a union representative anyway. You should have your ear to the ground out there anyway. So that's probably a you should have known situation. Okay. The key case, by the way, on this is a case called Hoggard versus PERB. It's a D.C. Court of Appeals case. The citation for anybody who's bothering, look, this is 655 Atlantic 2nd, 320. And this involved a school bus driver working for the DC Public Employment Relations Board. I'm not going to spend a lot of time talking about the case, but it is, I think, probably one of the most important statute of limitations cases under PERB. Okay? All right. Now, before I'm going to talk a little bit about, let me just stop with it. What's the rule of thumb? What should you get out of this? What you should get out of this is if you get a smell that the employer has committed an unfair labor practice, or if you get a smell that the union has committed an unfair labor practice, you better talk to your lawyer and don't just wait around. Those 120 days the meter is running, and you need to get thinking about filing a complaint. Maybe your lawyer may advise against it. Who knows? But don't just sit on your hands. Okay. Once you get a sense that something's wrong, the meter's running on you, and you may want to get cracking. Okay. Yes, sir.
Do you have to file, if an employee, does he or she have the right to file with PERB, or can it file on the federal level? If they do a violation has.
When you say federal level, you mean with the Federal Labor Relations Authority or the NLRB?
Yes.
If the employee is an employee of DC government, you file with PERB.
Okay.
The NLRB has no jurisdiction over DC government, nor does the Federal Labor Relations Authority. Okay. So you got to go to PERB. Okay. And importantly, by the way, you've got to go to PERB in most cases before you can go to court. There are some exceptions under the National Labor Relations Act where you don't have to go to the board first. You can actually go to court, duty of fair representation. But as I understand the law with respect to PERB, you need to go to PERB first. So you need to be alert, okay? Now, one of the things we've given you in your packet, because we are talking about complaints, sometimes, by the way, I will use the word charge, but that's because that's the term the board uses, the NLRB uses, and I just can't get out of my NLRB bag. So if I use the word charge, I'm really talking about a complaint. In PERB language, I'm talking about a complaint. Does everybody have one of those in front of them, a sample complaint? I'm not going to take you through this thing, but I just wanted you to have one in your folders so that, because many of you have some of you may not have ever had one. Maybe you have such great relationships, you never had to file an unfair labor practice complaint. So I thought maybe it would be good to have one in your folder. This particular complaint was prepared by the PERB staff, so it's right. It's what it's supposed to be. The only problem with it is a bargaining case, so it is a little more, perhaps more complicated than some of the other cases. For example, if you were filing a complaint about a discriminatory discharge, a union steward got fired, and you thought he was fired or she was fired because they were being tough stewards. The complaint you would draft would be a little simpler than this, because the issues are a little simpler, and the things that you have to establish as part of the case are a little bit simpler, okay? But this is to give you an idea of what one of these things we're talking about, these unfair labor practice complaint, look like, okay? Any questions about them? Does everybody have one? Okay, good. All right. Did somebody?
Are we gonna be able to go back to filing these manually, or we still gotta do it on the computer?
You have to file it by your computer, right? Okay. Although, as I understand it, particularly if if an individual is filing pro se, that is, if it is not a charge or complaint being filed by a union or complaint being filed by an agency, but it's just a rank and file employee who's got a beef against his employer, or a beef against the union, or maybe a beef against both. If they come down to PERB, the PERB staff will give them a hand, will help them prepare prepare the complaint. Okay, what we're going to talk about is the unfair labor practice provisions of the CMPA. And if you go to your binder, you'll see that the unfair labor practice provisions are set out at 1.617.04. 1.617.04. Okay. And if you look at them, you will see the first half of 1.617.04 is subheading A. And those are the unfair labor practice provisions that regulate employer conduct. And then 1.617.04B are the unfair labor practice provisions that regulate union conduct. Okay? What I'm going to do is I'm going to talk about 1, 2, 3, and 4 today of A, and I'm going to talk about 1, 2, 4, and 5 of B. So we will not get through A or A5 or B3. And those are the statutory obligations that unions and management have to each other to engage in good faith collective bargaining. That's for next month. That's for February. Okay. All right. Now, if you look at A1 and look at B1. The district and its agents and representatives are prohibited from one, interfering with, restraining, or coercing any employee in the exercise of the rights guaranteed in this subchapter. And if you go down to B, it is phrased very much the same way, so that both the employer and the union have obligations not to interfere with, restrain, or coerce employees in the exercise of their rights under this subchapter. Well, first of all, what does that mean? What rights do employees have under the subchapter? Whatever. Anybody know what rights do you have as an employee in the District of Columbia, as far as PERB is concerned? Anybody know?
To agree to help assist employees, create issues with the employer.
Right.
Work with the issue.
Exactly. And those rights are set out at 1.617.01. It's the right to join unions. And the interestingly enough, this statute, okay, is very, very reminiscent of the National Labor Relations Act. A1 and B1, okay, are almost carbon copies of what's in what is called A1 of the 8A1 of the NLRA and 8B1 of the NLRA. Okay? There's a little difference, however. In both cases, the NLRA refers to employee rights under the statute. This refers to employees' rights under the subchapter. But there is a provision in the NLRA that is not in not in CMPA. What did I say? I always get my letters reversed here. And what that is under the National Labor Relations Act, employees have a right to engage in union activity, to engage in protected concerted activity for the purposes of mutual aid and protection, or to refrain from that. So under the CMPA, they have a right to engage in union activity, and they have a right to refrain from engaging in union activity. The point being that there is just as much right, the AFL-CIO likes to say, has a phrase called union yes. Union yes. The point being that in the District of Columbia, employees in the District of Columbia have a right to say union yes. They have the right to be for the union. They have just as much right to say union no. So one of the rights that this is referring to is the right to be against the union. It's just as much a right, and that same right exists under the National Labor Relations Act. The right to say union no exists. But the difference between PERB and the NLRB is PERB doesn't have a provision in there referring to protected concerted activity. Under the National Labor Relations Act, you can engage in activities that have absolutely nothing to do with the union and still be covered by the National Labor Relations Board. Okay? And those activities are what's called protected concerted activities. Protected activities are activities in which employees get together to work on, to improve their wages, hours, and working conditions. And concerted activities are activities in which two or more employees are involved, okay? So if two employees walk into the boss's office in the private sector and they say, I'd like a pay raise, and the boss says, you two guys are wise guys. I don't like wise guys. I don't like guys who are always fomenting problems and worrying about pay raises. You're fired. That's an unfair labor practice. Okay? There's no union on the scene. These guys never even use the word union. Okay? That is an unfair labor practice because the employer has discriminated against them because of protected concerted activity. There is no counterpart to that in the CMPA. Okay? Now, what would happen, what would PERB do? I don't know. The simple answer is, if you had that kind of a situation, you should file. PERB will tell you. They'll tell you. But that's one of the differences between CMPA and the NLRA. Just as an aside, for instance, has anybody read anything about the Facebook cases involving the NLRB? Anybody heard anything about this in the paper? There's been a lot of, well, good, one person. There's been a lot of publicity about these cases. And what they are is they're protected concerted activity cases. They're cases in which employees put something on their Facebook complaining about the boss. Or a group of employees put something on their Facebook page complaining about the boss. The boss finds out about it and fires them. Why? Because they're insulting the employer. It's abusive. They doesn't think that's right. And the NLRB says that's protected concerted activity. Those guys are together trying to improve wages, hours, and working conditions. And their boss just discriminated against them for doing that, and that's an unfair labor practice. So this idea of protected concerted activity is not some ethereal concept that you never hear about. It's as current as the Facebook today. Okay? And one of the most important cases at the NLRB, early cases, was a case called Washington Aluminum. Right, happened right up here in suburban Baltimore. Employees showed up in an aluminum factory one morning. It's very cold. The heat was off. The employees refused to work. They walked outside. In effect, they struck. Okay. The boss came in and said, "Go back to work." And he said, "No," and he fired him. And that case went to the Supreme Court. And there was no union. There was no union at that plant. But it was so that was a protected concerted activities case. Those employees were concerned about their working conditions, i.e. cold in the plant, and they were engaged in concert. More than one of them was out on strike, and that case went to the Supreme Court, the board, and the employees won. Okay? So the point here is, I should probably spend more time on this than I should, but I should understand this concept, and if you had that kind of a situation and you weren't sure what to do, the answer is you should file with PERB. They'll tell you. They'll tell you whether it's an unfair labor practice or not. Okay? All right.
You're saying that it's not, right?
Ma'am?
For the district.
Well, it's not in the statute, but whether PERB would say, we think it's implicitly in the statute or not, only PERB can tell you, and the only way PERB is going to tell you is if you file a complaint. Okay, so if you had that kind of an issue, you need to file a complaint and let PERB tell you. That's the simple answer. Okay. All right. All right. I want to take you through some employer and union conduct that is violative or could be in violation of A1, okay? But it's very important you understand something here. If you notice that it says, interfere with, restrain, or coerce employees in the exercise of their rights in this subchapter. What does that mean? What was the DC City Council thinking about when they wrote those words down? How are we, some of you are non-lawyers, I mean, maybe even lawyers, how are we supposed to know what's interference, restraint, and coercion? Who's going to decide that? These are very vague terms. Who decides? The answer to that is PERB. The answer to that is the NLRB. Those agencies are what they're often called expert agencies. They're composed of people who understand the workplace, who know what it would be like if you were a worker in a DC office or in a factory, or you're a cop on a beat, or you're a firefighter, or you're working for WASA. They know what it's like to be out there. And they're able to say, gee, that kind of conduct by the employer, that does interfere, that does restrain and coerce. Okay? And that's why they have these expert agencies. Let's take an example. Interrogation. Anybody have any idea what the word interrogation means in the context of labor management relations? Yes, sir.
Maybe something that could lead to discipline, or,
Well, possibly, yeah. Okay. Anybody else have thoughts? Yes, sir. Discovery. Well, interrogation probably doesn't happen in the same way in the DC government that happens in the private sector. And why is that? Well, because most of the interrogation cases in the private sector really arise in an organizing situation, where the union's trying to get into the plant. They're running an organizing campaign. So much of the DC government is already organized that the kind of interrogations that normally come up probably don't come up as much. But what it is, by the way, it's a doctrine that the NLRB has that says asking employees how they feel about the union can be an unfair labor practice. That's what it means. Can be an unfair labor practice. In other words, the employee is sitting at his desk or is on his break, and the supervisor or the manager comes up to him and says, "Hey, Jim, the union's trying to organize here. What do you think about it?" Okay. Now, what the NLRB says, and by the way, what PERB says, there are some interrogation cases on the books in PERB. There aren't many. But what it says is that can be a coercive experience. Why? Anybody have any idea? Why would that be? Why, don't people have enough guts to be able to just look at the boss and say, hey, yeah, I'm for the union, or no, I'm not, or why don't you mind your own business? What do you think?
The employee can hold that against the employee.
Exactly. Well, let me tell you an experience I had it was about 10 years ago in one of my classes at Catholic University. I had a guy, we were talking about this very concept, and I had a guy in class raise his hand. He said, by the way, this is a kind of a guy who thought of himself as kind of a macho guy, and he was considered himself pro-management. He thought that the NLRB, even though he was taking my course, he thought that the NLRB coddled employees and didn't really understand what the real world was like for employees. So he raised his hand and he said to me, Mr. Higgins, I don't understand this doctrine. I think it's the silliest thing in the world to think that an employee could be coerced by the boss just asking him how he feels about the union. I said, okay, well, why don't we test it? Why don't we just test it right now? He said, why don't you stand up? He stood up. I looked at him and I looked at him very serious and I said, are you like me? whoa, whoa. Froze in his tracks. Froze in his tracks. I mean, he just turned, he just didn't know, breathless. He started to answer, and I said, put my hand up. I said, look, don't answer the question. Because, you know, I don't even care if you like me. That's not the point of this question. The point of this question is that feeling that you just had in the pit of your stomach when somebody who has leverage over you, I give you a grade, okay, leverage over you, asks you if you're with him or against him. Do you like me? Are you for the union? Either way, it's the same question, okay? And I said, that sickening feeling in your gut and that little trickle of water that's running down your spinal column right now, that's, you were just coerced. I just coerced you. And by the way, I went on to point out, I said, this is just a lousy 3-credit course in law school. If I flunked you, you still probably will graduate. Okay? We're not talking about you being a relatively unskilled worker in a place where there aren't too many jobs around, and if you get fired, if that guy fires you, you ain't going to work. You got to go home and tell herself that you just lost your job, and that we're moving on. I mean, it's a whole different world out there. Well, anyway, the board doctrine is interrogation is not per se unlawful. In other words, every time you ask, and for instance, if you're working in an office in DC government and your brother-in-law is your supervisor, and you're over there having Thanksgiving dinner, and he looks down the table at you and he says, "Hey Jim, how do you feel about the way the union's handling these cases?" Well, you know, that probably isn't terrible. That isn't really a coercive experience. So what the board says is it's all in the context, and one of the most important things is what the relationship is between the interrogator and the person being questioned, and the locale. If you're working out at your desk and the boss calls you and says, "Jim, come into my office, will you?" And he comes in, he closes the door, and then he asks you. That's a little more of a coercive experience. So anyway, that's all I need to say about that. It doesn't happen that much, but I want you to get a concept of what interference, restraint, and coercion is. It was the job of the NLRB to figure out what those words mean in that context. And they did, and that's what they came up with. Another example, promise of benefits. Again, in the public sector, you don't have it as much as in the private sector, and it mostly comes up in an organizing context. But where the employer promises benefits to employees. You know, if the employees vote against the union, I'll give you all a raise. Or if you speak against the union with your people, I'll give you a raise. Okay? Unlawful? Every day of the week. Every day of the week. It interferes with that employee's, the promise of benefits interferes with that employee's right to say union yes or union no. Okay? The boss has no business doing that, is what the PERB says. No business doing it is what the NLRB says. Okay? Another concept that in this A1 area, or A1 area, okay, is surveillance. Now, we all watch cop shows, and we all know that cops engage in surveillance and, criminals and so forth. But there is a doctrine in labor law called surveillance, okay, where the employer engages, is surveying or surveilling the union activity of the employees. Mostly comes up in organizing situations, where the union's having a meeting at a church or a downtown area or something like that, and it's scheduled for 7 o'clock, and at 6:45, all of a sudden, a supervisor's car pulls up, and out front, and he's just sitting there. He's just sitting there. Employees all see him. Are they coerced? Answer, you better believe it. And that is another example of 8A1 or A1 conduct. Okay? even the impression that they're doing it. The NLRB just had a case not long ago where the employer passes out a flyer. There's an organizing situation. The employer passes out a flyer in which on the flyer is, don't sign one of these cards. And it's a picture of a union organizing card, or union membership card. The union was on the scene, but had been kept very quiet that they were trying to organize. There was no publicity about this. And the employer all of a sudden is now flashing this card around. And the NLRB says, you know, that employer is giving those employees the impression that he's surveilling their activity, the impression that he's watching, okay? And that's an unfair labor practice. I got to tell you a story about a case I tried before most of you were born, okay? Down in Memphis, years and years ago, there was a union was trying to organize a burlap bag factory, okay? It was a, you know, it was minimum wage jobs, dirty, hot job, unair-conditioned facility, and the union was trying to organize them. And they had a big warehouse. The employees, the warehouse was full of burlap bags, and the employees had dug out a big hole in the middle of the burlap bags where they would kind of go in and talk union. That was where they had little union meetings, and if somebody wanted to ask questions of some of the organizers, the employee organizers, they could go in there and talk and so forth. So they're all in there one day, or a bunch of them are in there one day, and one of the women who was one of the union organizers looks up, and there up on the top of the ledge over the was the boss's son, and he's looking down and watching them. Okay, so we alleged, the government, the National Labor Relations Board, we alleged that conduct was unlawful. It was surveillance of their union activity. And the problem was we had to prove that the boss's son was a supervisor. He didn't have any title, he didn't have any rank and file. It was just he seemed to be doing rank and file work, but the employees knew that he was more than that. So I said to the woman, I'm examining her, and I said, she described the event, and I said, who was that? She said, Mr. Jones Jr. And I said, oh. I said, what is his job? And she says, well, she said, I don't know. I think he's just a watcher. He's just a watcher. That was enough to establish that he was an agent of his father, and therefore it was an unfair labor practice. But that watching of that union activity wasn't considered an unfair labor practice. Okay, let me see where I am in my notes here. I'm way ahead of myself. I'm going to make my targets here. Let's just spend. By the way, let me just jump over across the aisle, if you will, to B1. Okay, same language as A1. Okay, only this is restrictions on unions. Yes, sir.
If you know a union member, and he or she wants to leave the union and go into management, as a union, if I go to that individual and say, well, you know, going into management, this isn't the right thing to do, you know, you be at will, X, Y, Z can happen to you, you need to stay in the union, because the union, we can protect you, you have this right, you have that right. So will that be conceived as, you know?
Interrogation.
Yeah.
Okay. But that's exactly what you just asked the question that I was just going to ask. Is it the same? Is conduct by unions under B1 similarly unlawful as it would if it was by an employer under A1, which is what you're asking? Okay. And the answer is no. No. And why not? Who said no?
I did,
All right, why not? Why is it no?
because you don't have the ability to fire or have that.
Right, exactly right. The relationship is different, okay? If the man, so to speak, ask you if you're for the union and he or she can fire you for it, that's a whole different thing than if you, his union rep,
Right.
you don't have any power over him, right? You don't have any power. The only thing you have is the power of persuasion. Okay? The only thing you have is power of persuasion. And there's nothing wrong with trying to persuade people. Now, if you start on coercive things like, we know where you live, or activities like that, that is clearly unlawful. That is clearly unlawful. So there a union could be doing something like that. Or I have a good relationship with the supervisor, and if you start to act up at union meetings, I can have the supervisor sit on you. I, the union rep, okay? That would be coercive too. In other words, you are showing or suggesting that you are going to use your influence with management to do something bad against him. That would be an unfair labor practice. But the point is that the same kind of relationship, as this lady says, that exists between managers and employees and between unions and employees, it is a totally different situation. Okay? Any more questions on that? All right, let's go to A2. A2. I'm only going to spend a minute or two on this. This is a counterpart to a provision that is also in the National Labor Relations Act that makes it illegal for employers and unions to have sweetheart relationships. Now, the sweetheart relationship does not mean that there's something wrong with the employer and the union getting along well. Okay? Unions and employers get along very well in some very, very strong collective bargaining relationships. But a sweetheart relationship is where the union is in the employer's pocket. Okay? Now, interestingly enough, when Senator Wagner drafted the National Labor Relations Act in 1935, that's when it was first drafted, and he is considered the architect of it, he said, the most important provision of the National Labor Relations Act is A2, 8A2. And the reason why he said that was that when you have an employer who has some control over the union, okay, it really does undermine the concept of a free and an independent labor movement. I'm not talking about, when I say independent labor movement, I'm not talking that you could be an independent union, not unaffiliated with the AFL-CIO, and still be a tough union, okay? I'm not saying that. But a free and independent of the employer's influence. And if the union isn't a free and independent union, if it's in the boss's hip pocket, then that gives the employees the impression they've got a union when they don't. And that's what CMPA says is unlawful. That's what the NLRA says is unlawful. Now, yes, ma'am.
So that seems like a big distinction between, say, a supervisor who's supportive of the union as it's organizing. But my impression was if a supervisor says, oh yeah, I'm all for the union, while they're going through the organizing, that also could be considered a ULP.
No, it doesn't. I mean, there is a body of case law under the NLRA, and I'm sure there would be a counterpart if PERB had such a case, where the supervisors are actually out there trying to get employees to sign union cards, because they are. And by the way, I'm assuming that's an independent union. It's not the boss's union. The board or the courts have held, and the board has held, that that's objectionable conduct. That may be grounds to set it aside in election. Whether it's an unfair labor practice, a lot would depend on the circumstances. But most of the 8A2 union cases came up early in the history of the National Labor Relations Act. The board doesn't get a lot of those today, the NLRB. And I, by the way, went on the Bynes-Axelrad website to see if there were very many cases under PERB, and I didn't. I found one where there was an 8A2 allegation. I'll tell you what it was in just a second. But it can come up in in unusual situations that really are not, where the employer can get into it without realizing he's committing an unfair labor practice. Anybody ever hear of a quality circle? Quality circles? Okay. Well, it's a concept that came up in the 90s, where employers were trying to get employees to gather together at the plant and talk about how they could improve quality. Or they had employee committees who were talking about how they could improve production. And the question came up, were these unlawful unions? You know, they weren't AFL-CIO, they didn't say they were unions, but they acted like, if they act like a union, it's like that old proverbial duck, you know, quacking and walking and so forth, it is a duck. Well, if it's acting like a union, for example, if it's negotiating with the boss about performance, you know, or about wages, or about making a better product, or having things easier at the plant, if it's doing that, if they're really talking like, if they're exchanging their positions, then it may very well be a labor organization or a union. It could be an unfair labor practice. The board has had a few of those cases. The one case that I know PERB had, and by the way, PERB dismissed this case, involved a group of doctors from Public Health Service. This is back in the 90s. A group of doctors from the Public Health Service transferred over, and they were represented by a union. They transferred over to DC General, on the staff of DC General. And DC General continued to recognize their union and paid them at the contract rate that they had negotiated with the Public Health Service. That rate, excuse me, that rate was more than was negotiated with the union at DC General. So the DC General Union filed an unfair labor practice charge with PERB, alleging that, okay, that relationship between DC General and the union representing the Public Health Service doctors was an assisted or a favorite or a sweetheart union, and those employees should be merged in with them, and they should be getting the DC General contract wage. Okay? PERB says, no, okay, that's not what A2 is about, and more importantly, this is DC General just trying to honor the contract that these employees, these doctors, brought with them when they came over from Public Health Service. That is the only case. Do you know of any cases? Do you know of any cases where 8A2 has come up?
Yeah, there was a case involving the police department.
Oh.
A supervisor, I'm sorry, an officer of the police department union became a manager in a different agency within the police department. And there was an allegation that was, gave him the employer control, and that was dismissed.
Okay, all right. Okay. I mean, there is nothing wrong with supervisors being for the union. That's not a sin. That's not a sin. Okay, but there can be if they're out there putting the arm on people to get them to support the union. Okay, they're not in the bargaining unit. They're the boss, and they shouldn't be doing that. Okay, so there's a fine line to be drawn, and I think when a union person becomes a supervisor, I think probably in most employers do sit down and explain to them that their status is a little different now. Okay. Any other questions on that? All right, let's talk about A3 and A4. Both A3 and A4 involve, they're very similar to 8A3 and 8A4 of the National Labor Relations Act. A3 says it's unlawful to discriminate against an employee because of his or her union activity. Okay? And 8A4, or A4, says it's unlawful to discriminate against an employee because he or she filed a complaint, gave testimony under the Act, assisted other employees in filing a complaint. Okay? So in both cases, the usual problem is a discharge. Okay? The usual problem is a discharge or some sort of disciplinary action. Has anybody here been involved in a PERB case involving A3 or A4? Anybody ever been? Yes, ma'am. Did you have it? Did it go to PERB?
Yes.
How'd you do?
Not too
Not too good. Okay. Well, were you on management or union?
bad.
Oh, you're in management. Okay, so the employee one. All right. 8A3 cases is the way it's referred to at the National Labor Relations Board, are probably the most common type of unfair labor practice charge one gets in the NLRB. And almost always, they come up in an organizing context. Okay? And by the way, these are employees who don't have any, they're in the private sector, so they don't have any civil service protections either. Okay? What's involved in these kinds of cases? Well, almost invariably, there are cases in which the employer alleges misconduct that has nothing to do with their union activity. Okay, the employer, I fired him because of tardiness. I fired him because he's a drunk. I fired him because his work is bad. Whatever it happens to be. And the issue for PERB, and the issue for you when you file, if you file your complaint, is establishing that that statement ain't true. Okay, that it's a pretext, as the NLRB or as PERB would say. It's a pretext for what he was really trying to get at, and he was after this guy because he's a tough union steward, he's a union organizer, or something like that. Okay. Well, how in heaven's name do you prove it? Because you, by the way, at the NLRB, the general counsel is the prosecutor. He and his staff, they'll prove it for you. They'll go investigate it and prove it for you. How do you prove it? How do you, all you can do is file a complaint with PERB. You've seen a copy of it right there. How do you go about proving that it's a lie? It isn't true. What would some of the evidence be? What do you think would be evidence? What should you be looking for?
Character of the employee.
Character of the employee, that's his employment history, yes.
Yes.
Okay, okay. Anything else?
Case laws of which he's won,
Pardon, what's that?
case laws of which he's won, or.
Well, yeah. Yes, ma'am.
I think one of the big keys is time.
Perfect, yes, absolutely. That's right. What was the timing of this? Did this happen the day after the boss discovered that this guy was a union supporter? Or did this happen a couple of days after the employer and this union steward got into a big argument at a grievance meeting, and the supervisor told the boss to go to hell, and the boss was upset, and you can't talk to me that way. And then 2 days later, gee, all of a sudden his work is bad. Okay? Is that what happened? That's the thing. That's another thing you look at. What else? Anything else?
Disparate treatment.
Absolutely. Oh, who said that? You and you. Okay, two people. Okay, disparate treatment. Okay, have other people been tardy and weren't fired? Have other people had bad work? Are other people having drinking problems on the job and nothing's being done about it? Okay. Well, if those are the kinds of things that you're able to establish, then it starts to, the answer becomes pretty obvious. Maybe it wasn't tardiness. Maybe it wasn't drinking. Maybe it wasn't bad work. Maybe the timing was perfect. Maybe it was union activity. Okay. By the way, one of the most important issues, no one mentioned, but ordinarily it would not come up, I think, in the D.C. government, where people's union sentiments are pretty well known. But in an organizing campaign in the private sector, if there's one thing most employees don't want the boss to know, it's how they feel about the union. So it is a very important part of the government's case to establish that the boss knew they were for the union. Okay? Now, in the hypothetical that I gave you, where there was a screaming match between the steward and the manager, that's pretty obvious, okay? But if it's an organizing case, or if the employee is just another union member, doesn't do anything, he's not active in the union and so forth, and all of a sudden he gets fired, and you want to establish that that employee get fired for union activity, you've got a hard road to hoe, okay? Because you've got to establish that this was what motivated the employer, okay? What if they, instead of going after you, they go after your brother, or your sister-in-law, or your mother? In other words, the boss decides, look, I can't be as obvious as firing that guy, he's a truly troublemaker, but, you know, I'll teach him a lesson. He'll get the message, and I'll cover it up beautifully. So I'm going after his mother. His mother works at the same office. Or his brother or his sister-in-law works at the same office. If I can them, and I got a reason for canning them because she's always late for work. So I'll fire her, and he'll get the message. And it'll hurt him. It'll hurt that family. That's what I want. Illegal? Every day of the week. Every day of the work. Every day of the work. That employer is discriminating against an employee not because of her union activity, but because of union activity or protected activity of people that she knows. It doesn't have to be a relative. It could be a friend. Okay? The point being that the employer can't discriminate on the basis of union activity. Let's jump over to the other side. Oh, by the way, before I jump to the other side, 8A4. 8A4, we were talking about union activity. Just take that out of the mix and add in filing a complaint with PERB, giving an affidavit to the union for use in a PERB proceeding, testifying in a PERB case, anything like that. That's protected conduct. That's protected by A4. And almost always you don't have a problem with employer knowledge about that. Okay? So those are A4 cases. I don't know how often you get an A4 case at PERB, but it is an extraordinarily important provision of the statute as far as PERB is concerned. At the National Labor Relations Board, when we got an 8A4 charge, we turned over every single rock we could find to make sure that those employees were protected in their access to the board. The board always views that as an extraordinarily important part of it, protecting people's right to come to it. Okay? And I think probably the same thing would be true at PERB. All right, jump across. When I say jump across, I mean we're jumping across from 8A to 8B. Okay? And let's look at what it says about discriminatory discharges. Two, causing or attempting to cause the district to discriminate against an employee in violation of 617.06. Okay? 617.06, if you move over to 2 pages, you'll see the statement of what it's about employee rights. Okay? It's the same, basically the same thing. And this is a recognition by the DC Council, City Council, just as there was a recognition by Congress, that the union doesn't have the power to fire people, okay? But it can have a very strong influence to get at its enemies, if it wanted to get at its enemies. And that's what this particular provision says. So when a union causes or attempts to cause, okay? So it's just as much an unfair labor practice if the union just asks the supervisor, hey, you kind of ride herd on that guy. make his life a little bit miserable. We want to get a message to him and maybe even fire him because we don't want him in our union anymore. And the supervisor says, hell no. I went to the Higgins class. I went to second Tuesday. I know I can't do that. Yeah, okay. That's an unfair labor practice, though. He just attempted it. Okay? So a union asking to do it is just as much an unfair labor practice. Okay. Now, I'm going to, okay. I want to talk a little bit about the duty of fair representation, but I'm not sure I can get to it. But let me just talk about the remedy. Let's assume the employer fires the employee for union activity. Private sector, PERB, whatever, doesn't make any difference. Or let's assume the union attempts to cause the discharge of an employee and is successful. Okay? What can PERB do? What does PERB do? What do you get out? If you file a complaint with them, what do you get out of it? Sure.
Make it known that they lost, I guess, whatever the case.
Okay. Okay. But what about the guy who got fired? What does he get out of it? And reinstatement. Okay. And what else does he get? Back pay. All of it. What if instead of while he's laid off, he starts driving a cab for his brother-in-law, and actually he makes more money driving a cab than he did working for DC government. But he still wants his job back because he loves the pension. He loves working. Okay. What does he get? Does he get any more? Does he get any money?
Well, it's paid.
Huh?
It's offset by the amount of pay that they care.
It's offset, yes, ma'am. Okay. The PERB and the National Labor Relations Act makes the employees whole. They're not supposed to make money on it. Okay? They're not supposed to make money on it. Now you can make an argument that there should be damages, and I think it's often that argument is often made by the union, by the union movement, that there should be damages. But that's what Congress and that's what the DC City Council chose not to do. What if, while he was fired, his wife had a baby, and he had to, he lost his insurance. He's still working for his brother-in-law, made a lot of money. Okay, by the way, he made a lot more than he would have made. In fact, he made enough to pay for that baby in the hospital and the pediatrician, obstetrician. Does that change your story? Yes, ma'am.
No, it doesn't matter.
Anybody, she says no, he doesn't get any money, right?
No, I didn't say
Oh.
that. I said, no, it doesn't matter that he's made that much money.
Yeah,
If
you
he's
are
gonna
right.
be
Yes, ma'am.
made whole,
Yes, ma'am.
then we have to reinstate that health insurance.
Right. And if he had to pick up that tab, that would be one of his losses.
Correct.
As a result of he losing his job unlawfully. Okay, so there's a whole huge body of law which is called compliance law, and if you end up in one of these kinds of cases, believe me when I tell you, your lawyer will figure it all out for you. So there's not a problem there. But there's another aspect to it too, and that is usually it does require that there be a posting of a notice in the workplace by the employer saying, we will not discharge people because they're for the union. We have reinstated John Smith. We've made him whole for any loss of pay as a result of as a result of our discriminatory acts against him. Okay, so that's yes, sir.
One of the differences I noticed in reading NLRB cases when people are reinstated is that the NLRB will order the employer to pay the taxes and the applicable tax
Yeah.
year, and it
Yeah.
goes back to the board to let them know it's been done. Generally, in arbitration is how we handle our reinstatement cases, so that particular provision doesn't apply. But when our guys get reinstated and they get a lump sum to be made whole, it throws them into a whole tax bracket.
Well, you ask the arbitrator for it then. That's something you should ask the arbitrator for. And the gentleman is right, by the way. For a long time, what would happen, employees would get a huge bunch of money, maybe 2 or 3 years of back pay. Maybe it took that long to litigate the case. And they get a big bundle of money, and it all came due in one tax year, and they had to pay at a higher income IRS rate. Okay? The board finally, and by the way, we in the general counsel's office argued against this for a long time. We finally got the NLRB to agree to an order that says, to the extent that this employee loses money, has to pay additional tax, that employer has to pay that too. And there's absolutely no reason why an arbitrator couldn't give that kind of award if he or she wanted to. And the only way they're going to do it is, you got to ask them. You got to ask them. Yes, ma'am.
Is the posting period for notices negotiable, or does the board define, for how long and the locations of those postings?
The board does not consider the posting of a notice a negotiable item. And by the way, what the board will tell you is, and I'm sure PERB would have the same argument. The remedies under CMPA or the remedies under the NLRA are not as meaningful as they could be. We ain't got much, and we're not going to give what we got away. Okay, so you got to post a notice, and you can't put something in the notice that says, what's called a non-admission clause. You can put that in the settlement agreement, but you can't put that in the notice. So the answer is, the board does not negotiate that away. However, okay, if the union and the employer kiss and make up, okay, and they both walk into the NLRB office and they say, look, we struck a deal, and our deal is to withdraw the unfair labor practice charge. The board will accept that, and if that would often accept that. And if that may mean no posting of a notice. That may mean, sometimes it means no back pay, or sometimes it means lesser back pay. But if the board is satisfied that it is a true settlement by two equally powerful partners, then the board will permit a withdrawal in that case.
One question.
Yes, sir.
Another question. You have a term employee. Most DC government employees come in term temp. And you got an employee that's been a term or temp employee for 2 years, 3 years, 4 years. All of a sudden, he or she becomes heavily involved in the union, becomes a shop steward. Their record has been excellent in evaluation. So their term comes up to be renewed or let go. Management decides, we're not going to renew your appointment, we're going to let you go. And you've been there for 2, 3, 4 years. Outstanding employee. As soon as you get involved in the union, we do not renew your appointment. Does an employee, everything else, come to work on time, no other problem. Does that employee have a legitimate case to bring to the union to file the PERB?
Absolutely. 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 And in terms of what happens when that case gets to PERB, you've met Ann, you've met Don Wasson, they're your two PERB members. They weren't born yesterday. I mean, they're going to figure this out. The facts are as you describe them. They understand what's going on, and you'll probably win, okay, if it's as bad as you describe it, okay? That's why you have experts working at PERB. I didn't finish what I wanted to finish. We have to do it next, we have to come back next time. I want to just touch very quickly on something, and then I will spend some time on it, because I think there are a lot of these duty of fair representation cases. And I think it's very important that we spend, I don't just try to jam it in at the end of this class. Let me just quickly find my notes here. The duty of fair, well, we've been talking about union and employer unfair labor practices. And each time I pointed out to you where in the Act, CMPA, or where in the NLRA, you could find those unfair labor practices. There is an unfair labor practice called a breach of a duty of fair representation. And by the way, one could argue that it also is a breach of the standards of conduct under the CMPA. But whether it is or it is not, the breach of the duty of fair representation, okay, is a breach of the union's duty to represent all employees in the bargaining unit equally and fairly. All right? Now, if you go to the Railway Labor Act and looked up in a text, you would find a whole big chapter on the duty of fair representation. For the railway unions and the airline unions, those unions have a duty of fair representation. And so you go to the Railway Labor Act and you open it up, not word one mentioned in there. Similarly with the NLRB, if you go to the NLRA and you start looking at the board volumes, you'd see a lot of references to the duty of fair representation. But if you went to the statute itself, you wouldn't find it. It is arguably in CMPA under the standards of conduct, okay? But whether it's there or whether it's not important. The fact of the matter is, every union working under a statute has a duty of fair representation. And where does it come from? Why would there be why would it be an unfair labor practice for a union not to fairly represent employees when there's nothing about that in the statute? And the answer goes back to, believe it or not, 1944 in a case called Steele versus Louisville and Nashville Railway, where a case went to the Supreme Court. It was a black employee working, I'm not sure what, maybe the Brotherhood of Railway Reporters, I'm not sure. No, it was another union. In any event, he alleged that the seniority system, or was it the pension system? I'm sorry. But it was something that was set up and it discriminated against black employees. Okay? And what the Supreme Court said was, the union has committed an unfair labor practice because the union has an obligation to represent all employees in that bargaining unit fairly and equally. Why does it have that duty? It has that duty because Congress gave that union a license to represent those employees exclusively. So when a union accepts a collective bargaining relationship, okay, it represents all of those employees. That's a lot of power. That's what the Supreme Court. It's a lot of power, and they speak with one voice. That's why they call them unions. So if we, the government, are going to give employees give unions that kind of power, they've got to treat only they can speak for those employees, and they've got to treat all those employees equally. That's what the duty of fair representation is considered. Now, let me just say, why don't I stop there? I really hesitate to try to kind of finish this out. We were supposed to be out of here at 11:30. Why don't we take any more questions about anything else? And what we'll do is, I promise you, we'll spend some time in February talking about the details of the duty of fair representation. Because by the way, it isn't as simple as that. You may say, "Oh, does that mean I have to represent everybody all the way up to the Supreme Court?" And the answer to that is absolutely no. It doesn't mean that. It just means that you've got to treat everybody equally. Okay? If you think it's a lousy grievance and you want to say, "Get out of here! I'm not going to process that grievance for you," and your heart is pure, you're doing it in good faith, you're home free. Indeed, you may even have an obligation to say, "I'm not going to process lousy grievances," because if I process lousy grievances, I jam up the grievance arbitration machinery, and then the good grievances take forever to get to that arbitrator. So I may even have an obligation to say no. But we'll spend some more time on this because PERB gets a lot of what I call DFR cases, okay? And this is something you should all be very familiar with. Yes, sir.
You have this is a quick question. A president that chooses not to investigate, and then he chooses not to do the grievance. you actually go off to the grievance yourself and win the case yourself, do you still have recourse against the union?
Well, I don't know. I mean, I need to do a lot more about that. Let me tell you, there's a word that that PERB uses, there's a word that the NLRB uses, there's a word that the Supreme Court uses, and the word is perfunctory. Okay? If you have a union that acts like kind of acts like a union, but doesn't really do its job, it just goes through the motions. Just goes through the motions. That's not performing your duty of fair representation. Okay? You have an obligation to investigate. Now, when you investigate, and as a union, you investigate that grievance, you find out you don't think there's any merit to it, you may have an obligation to just say no. Or you have an obligation to say yes. But you don't have a right to engage in perfunctory treatment of members of the union. By the way, it's not members of the union. Okay? It's not members of the union. It's employees in the bargaining unit. Employees, as you all know, don't have to be members of the union. They have to pay dues, but they don't have to be members of the union. Okay? So can you treat somebody differently because he pays his dues and pays them grudgingly, all right? And do you have to treat him the same way you treat your brother-in-law, who's one of the best union guys in the whole world, and actually makes contributions to the union at the end of the year because he loves the union so much? And the answer to that is, yeah. Yeah, yeah. Exactly the same way. Exactly the same way. All right. Should I stop? Okay. All right. I'm going to stop now. We'll spend some more time on DFR next time, I promise. And then our subject for the next class will be obligation, the duty to bargain. We'll be talking about what your obligations are as managers and as unions at the bargaining table. Okay? Thank you.
Okay. I just want to remind you, next time, please send your emails, let us know you're coming. And that way we can decide whether or not to get a larger room or split into sections. And also, if you have any suggestions, feel free to send me an email, query.martin@dt.gov, and so that I can consider whatever suggestions you have. And thank you very much for coming. Thank you, Ms. Lord.
Yes, ma'am.